Thank you very much for that nice introduction. When my wife recently arrived back after many years overseas, we renewed our acquaintance with Robert Pope. We had last met when we were in our 30s, but I got pleased to say he hadn't changed very much. Robert asked me at the outset what I thought about moral law. I hadn't really thought about it actually, but then Robert went on to say, well, how do you think moral law would impact on his 21st century renaissance? And which he was just about to begin work on his book. And so I gave some thought to that and made a contribution, I hope it's useful, in Robert's book, The 21st Century Renaissance. Today I've been asked just to speak about international law. It might not be as light-hearted as Dr. Yaxley before me, and it might be a bit dry, but it's just how, I want to say, how international law fits in to the whole equation and where it's been leading us in the last several hundred years. Orthodox theory of international law, international moral law, under the authority of the United Nations, universally adopted by sovereign states and incorporated into national laws, should prevent the outbreak of new laws and engender global peace and prosperity. This philosophy of international relations was first recognised by the League of Nations in 1919 and was fully reflected in the 1945 Charter of the United Nations. The United Nations Charter itself resolved to establish and maintain international peace and security in conformity with the principles of justice and international law, and to promote the peaceful settlement of disputes. And you can reflect on that and see, after 50 years, and see how far we've come. International law dates back to the 1600s in Europe with the treaties of Westphalia, after many years of war in Europe. From the outset, it was very much the product of Western civilization, the Christian heritage and free market ideology, dominated for the most part by those states who had at that time built up extensive colonial empires, and that was the situation then. In time, these European states entered into treaties with other countries, such as the Mughal Empire in India, the Ottoman Empire, Persia, Japan, China, Thailand, amongst other countries. So it was all expanding fairly rapidly, even that long ago. All this changed after the First World War, with the rise of the USA and the emergence of socialism, and in 1917 the Soviet Union. It also marked the end of colonial expansion, the beginning of a process leading eventually to the collapse of colonial empires in the 1960s. The League of Nations was set up in 1919 and gradually came to be dominated by Britain and France. Little progress was made in drafting new laws, but conflict between states continued to increase. Modern international law made a great leap forward in 1945 when the League of Nations was recreated as the United Nations. The basic principles of the UN Charter were framed by the then major Allied powers, China, the Soviet Union, the United Kingdom and the USA. At the founding conference in 1945 in San Francisco, delegates from 50 countries blamed what they called a fundamental neglect of moral values by civilised governments for international tensions that eventually led to the Second World War. They agreed resolutely on the need to moralise the law of nations as the basis for future international peace and security, and to promote the peaceful settlement of disputes between states. Now, until that time, until 1945, international law had been shaped by a restricted group of mainly Western states And at that time, Africa and much of Asia was under colonial rule. With the Charter, self-determination became a right of all states for the first time, and with only a few years, remnants of the old colonial empires were being dismantled. The Charter introduced the principle of non-use of force by states into the international legal order, and for the first time, sovereignty became the equal right of all states, both rich and poor. The Charter also introduced human rights to a new moral world order, which in the years since has had a significant influence on the basic concept of international law. With respect to the making of new laws, the United Nations General Assembly has been given the task with their progressive development and codification, putting treaties into words and rules and regulations. Here, Western states preferred international laws to reflect their own familiar domestic common law or civil law systems. On the other hand, the Eastern European countries were cooperative, provided that the international laws supported their sovereignty, peaceful coexistence with other groups of states, and that the legal principles were acceptable to their socialist political philosophy. Through the 1960s, at which time states were invited to offer their views on the Charter, the basic principles of the Charter were elaborated, debated and defined in more detail, such that an international consensus was gradually achieved on many important new laws, chiefly laws involving morals and ethics. By this time, with new member countries rising from the old colonial empires, developing countries constituted an overwhelming majority of members in the United Nations. International law was relevant to them to the extent that it protected them from powerful states, but also enabled social change and more equitable conditions for economic activities. By that I would say chiefly their ability to attract loans. They could thus easily effect change with the support of the socialist states by virtue of their majority in the General Assembly. In parallel with these developments, on the other hand, new international trade laws and regulations of international trade and commerce has promoted an expanding global market economy, particularly in the latter years through the 1990s and the early 2000s. In 1994, the World Trade Organization came into being, taking over from the General Agreement on Tariffs and Trade. International trade law derived mainly through bilateral and multilateral investment treaties and subsequently subsumed into national legal systems in that way. So, post-1945, we find ourselves 50 years later, and what has happened? We can see that in the 6 decades since 1945, international law has grown exponentially and has spread to all fields of human activity. However, they have not ultimately penetrated many developing countries, and so are not always reflected in national laws of individual states, particularly the developing countries. In summing up, I would say it is relevant to ask if the resultant new world order is more harmonious, more peaceful, or more prosperous than before. And I have to say, sadly, no. We find today a global breakdown in law and order, failed states, and increasing anarchy, ethnic, religious, and civilisational violence in much of the world. We see a general weakening of family, declining standards of living, terrorist organisations, civil wars between vested interests, and growing illiteracy. We see a revival of non-Western cultures and apparent decline of the West. We have a lingering global financial crisis, with most industrialised countries mired in debt. Recovery is being financed by borrowed money. such that global sovereign debt now stands in the region of 45 trillion US dollars and increasing by $8 billion every day. And I would just conclude by saying that the world indeed is in desperate need of a 21st century renaissance. Thank you.